Greetings and welcome to another edition of the Ad Astra, the Kansas Money Talks podcast. I'm Joe Blubaugh, joined by Mark Johnson and Bob Schwartz of Schwartz Investment Partners, and they have offices in Victoria and Silver Lake, Kansas. You can find them online at schwartzinvestmentpartners.com. And, of course, all their contact information is there. That's the best way to get a hold of these gentlemen. And if you're watching us on YouTube or listening to us on your favorite platform where you get your podcast, we'd really love it if you'd give us a thumbs up and subscribe and do all the things. That really helps us out as we try to spread the word about the things we talk about. And today, we're going to talk about a topic that is something that's a little bit close to home for me right now because I'm actually going through this process, and that is trusts and wills and what needs to be done. And we're going to specifically talk about which is right for you. Now, obviously, we can't say which is right for anybody that's watching or listening. Every case is going to be based upon your situation, but we're going to talk about some guidelines. So. Yep. We'll get into that, and as I always normally do, I turn to you first, Mark.
Oh, yeah.
You're the teacher, and why don't you give us just a quick overview? What is a will?
Yeah. It is, to make it really simple, a will is what a majority of people in the United States, kind of what they need for estate planning, where they need to start. It's a legal document outlining how assets are distributed after death. So it is just protecting what your interest and what you want. If something would happen to you and your spouse or you, whatever it is, but naming guardians for your kids, assets, all that good stuff, but trying to, avoid things happening after death that you didn't plan for and didn't want.
So, Bob, I'll turn to you on this because Mark had mentioned that this is also a place where you can name guardians for your children. So I'm going to go out on a limb here and bet that wills need to be updated over time.
Well, I sure think so. I think the attorneys, I'm going with a client and it's their 3-year checkup. So they do it about every 3 years. Young people need wills because of their children, and it saves family. If something happened to the mom and dad, there's a terrible amount of grief there, but also it causes, if there's not named who's supposed to take care of those children, that can cause a lot of friction in a family because there might be a lot of relatives that would want to help with those children, and young people need to have wills for that reason.
Yeah, and I would assume that those will need to be updated, obviously, as they have more children, and then again, as those children start to hit the age of 18 and they become adults on their own. So something that you want to consider a living document, an organic document that you are going to update over time. So I'll turn back to you, Mark. Before we get into wills versus trust, what is a trust?
Yeah. First of all, there's also all different types of trusts. So I'm just going to go over basic. What I'm going to talk about mostly is like a basic living trust. If you really get into trusts, and you can understand that there's a lot of different types, lots of different options that can do different things. But for today, for the most part, unless we say differently, we're just going to be referring to a living trust. But it's a legal arrangement where a trustee manages the assets of a trust. They can take effect during your lifetime. That's why we call it a living trust. But it gets to avoid probate and offers privacy for the family. And you can also still have wants and wishes for your distributions and how it moves. So it's pretty powerful. So living trust, it's kind of what we're talking about right here. But yeah, it's a pretty powerful document for a lot of people.
You mentioned probate, and let's take just a second to talk about that because a will goes through probate. And a probate, if you're not familiar with that term, and I'm definitely not an expert on it, but the court system. Mm-hmm. The courts are going to look at that will and interpret it, and that could take some time.
And money.
Yep. Good point. Whereas a trust, you can avoid the probate as long as your trust is set up correctly.
Yep.
Yeah. And then Bob, as we talk about will versus trust, and we're going to go through some of the details of it, but in general, when I heard what Mark said, I was immediately thinking, okay, if you have a fairly simple estate and maybe not a ton of assets, maybe the will is the way to go. But if you start getting into some rather large assets, maybe you have multiple pieces of real estate, farm ground, whatever it might be, that's where a trust probably becomes a little bit more of a tool that you can use.
Absolutely. In Kansas, a smaller estate can transfer on death or payable on death. So a checking account can be payable on death, does not have to go through probate. Small estate.
Yeah.
Okay, that means accounts under, I believe, 50,000 in Kansas. Not estates under 50,000, but the accounts. So that becomes a very good way for people to to use a will, but to escape probate, because they can transfer on death. Like say they own a home, that's all they own, and TOD that, and then there's no probate process. That's pretty neat there, but you hit the nail on the head. Somebody's accumulated farm ground during their agricultural career. They've got an estate, $3 or $4 million. They probably want to have some type of a living trust.
And let's also look at, most people, their retirement assets are in a 401k or some kind of an employer type retirement account. Those also can be they have beneficiaries. Beneficiaries, yes. They actually take precedence over a will, do
that
they
is
not?
Outside of probate, yes. Your IRAs, your Roth IRAs, they have beneficiaries, just like a life insurance policy would have. And so consequently, they are outside of the probate process.
And that brings up another thing. We talk about wills, updating your wills. Update your beneficiaries, because
Yes.
Those, you get married, have kids, make sure your contingent beneficiaries are what you want. That's something that we try to be really on top of people and send out every year. Like, hey, do you want to let's look at this every year is a good annual review of your beneficiaries is a really good thing.
And Bob, I'm assuming over your lengthy career, you've probably come across a time where somebody has gotten a divorce and not updated their beneficiary, and an ex probably got a sizable chunk of change at some point.
Have seen that, yes.
Yeah.
But not very often, but I have seen that.
Yeah, so super important to keep those beneficiaries up to date. If you have any major milestone in your life, always a good opportunity to look at all your assets and who's going to inherit those upon your passing.
Most of the time when we see people separate and go through a divorce process, both sides are usually pretty proactive at getting those changed. I don't understand why.
It's crazy how that
They're generally very proactive at that.
The other thing I'd say is if you have an individual brokerage account, which a lot of people do, it's an incredibly flexible way for people to invest and save, something we really encourage a lot of people to do. But if you have one, you can create a designated beneficiary plan on your individual's account too.
Yeah.
And so that allows that same thing to occur where you have that designated beneficiary for it, and if something happens to you, it automatically goes.
And those are relatively new.
Yep.
So if you have a brokerage account that has been around for, let's say, 5 years or longer, in a brokerage account, a joint tenancy or a trust, the trust has a beneficiary named already, but a joint tenancy or an individual account that is not an IRA or a retirement plan of any type, you can put a designated beneficiary on that, which will pass right to them with a death certificate and proof of who the designated beneficiary is.
Yep.
Very good. Well, we've already touched on this a little bit, but let's talk about the differences between a will and a trust. We've kind of already mentioned wills are more on the simpler side, trusts are a little bit more complicated. Yep. Usually simple versus complicated usually means there's a cost difference in that.
I'd say that's the first one. You can get a will done for $100, a couple $100. You can go online to certain companies and have an online
99
order,
bucks, yeah.
draw them up, and then, probably do what you want it to do. For the most part, trust can be a pricey thing, especially depending on where you live. If you're on one of the coasts, I'm guessing a trust is pretty expensive here in Kansas. Even we're talking
A few thousand
at least a
minimum.
few $1,000.
Yeah.
Yes.
Yeah, I would say that a number I've seen for a number of years is $3,500.
Yeah.
Just kind of
Yep.
a rule of thumb, right
Yep.
in the middle there. But yeah, Kansas City's going to be higher, or Wichita's going to be higher, and rural Kansas probably going to be a little bit less.
Yeah, so definitely a cost difference in there. What about flexibility?
Yeah, trusts give you more trust. The whole the reason they cost more is they can become more complex, and that complexity also can be beneficial for you. I mean, you have a lot more things you can do within your trust, and so
You can set up,
you can set up whatever you need.
You
I
can
was just
set
gonna
up
say-
trust within a trust.
Yeah.
The way I've always used it in my mind, and this is a topic that I really don't feel like I have a good handle on, but the way I've always thought about it is, okay, if I have a will, I'm dictating how things will pass at my passing. Whereas if I have a trust, I'm going to still be able to control that money beyond the grave to a certain extent. I will have a certain amount of control, and that comes in important, as we've already talked about, if you have a minor child, but it also could be important if you have a special needs child. It could be important if you have children that either aren't good with money, or maybe there's an addiction problem that's in there, and you still need to control that money. You want to take care of your heirs, but you still feel like you need that bit of control even with you being gone.
You've got a child or children that are in a business operation with you, and you have other children that are not, and it allows that kind of flexibility. Not that a will doesn't in terms of leaving assets, but the trust owners can set out in a trust much clearer for the beneficiaries to understand what the grantors, otherwise mom and dad, wanted. And the clearer you make that for your heirs, the less chance there is of the heirs getting crossways with each other. And believe me, in 49 years plus, I have seen things blow up because mom and dad didn't get it quite right.
And we've also touched on this, but it's worth repeating again. If you do just a will, it's going to be in the courts, which means it's out in public.
Yep.
If you do a trust, that gives you some built-in privacy.
Privacy, and most of the time with the will, like probate takes about 6 months, so getting it settled quickly, that's not going to happen that way. Well, a trust, on the other hand, some money can start to be distributed immediately. But the second thing is, you have 5 years to liquidate that trust. So if there are assets in there that need to be title changes, etc., there's not a race going on that the trustee has to get it done today. They've got time.
Very good. Yep. We've also started to talk about this, but let's talk about who should consider a will and who should consider a trust.
Yeah.
Specifically, and once again, this is a question of you gentlemen, because I'm not an expert on this, but if you go, it doesn't have to be one or the other. Pretty much, a lot of times the will works in concert with the trust.
Yes.
It's the trust is a step beyond.
Yep.
I think our viewers are looking at a perfect example sitting here at this table. Needs a will, young children.
Yep.
At least needs a will because of young children. Mm-hmm. You already said it, working on your trust.
Right. But still need a will because I still have a minor child.
Yeah, and a pour over will, and me, I have a trust. Okay, so will, young person with a family, trust, 50s, built some assets, time to have a trust. Old man, trust. And that, that was simple, but I'm sorry. Now,
no. That's I think you've hit it on the head. So.
I was going to frame it pretty much the same way.
I'm sorry.
But no, that was good. I was gonna say, like me, someone who has young kids, like that's where we want to see you starting a will. If you're starting your family,
That's the least you should have.
Yes, when you start your family, immediately, don't you want to at least know, like, hey, if something happens to us, where are my kids gonna go? Like, you want to have control over that. And so, yeah, simpler estates, people that can POD things, you can probably create a pretty good estate for yourself, estate plan for yourself, just using those things if you have a pretty non-complicated situation.
So real quick, TOD, transfer on death, POD, payable on death.
Yep.
But I just kind of had one of those moments, and I think people know this, but I think it's worth saying. So many times when we think about a will, we think about money, and it's an assets transfer. But in this regards, it's really the most important piece of that will has to do with guardianship, and it really has nothing to do with money.
Yeah.
So
In Mark's case, absolutely. Or not Mark, but young people with children.
Mm-hmm.
You might have zero assets, but you need a will, and so it explains what happens if you and your wife are gone, and you need two wills to accomplish that and get it right.
yeah, okay, very good. So trust.
Yeah.
So we kind of put this general rule of if you've accumulated some assets, maybe it's a good time for a trust, but it doesn't have to necessarily be that you have a ton of assets. You could just want privacy, or there could be a lot of different reasons. But what are some of the main reasons why people would want to trust?
Avoiding probate. That's one I probably hear the most is, hey, we want to avoid the probate process. We have real estate. We have real estate in different counties, different states, and they want, just the more variables that go into your estate, the more a trust makes sense. So you want to have your privacy. We talked about all this, I think, but yeah, the biggest thing I can think of is once your financial situation becomes, I got money over here and here and here and these assets, and I have 3 kids and I have these grandkids, and I want these I have this plan in my mind. The trust is going to help you execute those things.
So Mark mentioned something, and I hadn't really ever thought about this, but if you have assets in multiple states, how does that kind of complicate an estate, and why does that really maybe make you want to really think about a trust?
Anybody that has a trust, if they go and look at it, if they did it in Kansas, it'll say under the laws of the state of Kansas at the time of the signing of this document. It doesn't say that exactly, but that's what it's about. And so you own farm ground in Iowa, and lucky for you if you do, and Kansas, and you're domiciled in Kansas. From what I understand, that ground in Iowa will transfer under the laws of the state of Kansas, and it will be the same. I think the one state that gets kind of different is Louisiana, which
Someone's got to be complicated.
Yeah, they don't call a county; it's a parish.
Yep.
Right.
And their law, they have French. Their laws are based on France's legal system versus ours is based on England. So there's some differences there. Don't ask me why. What? But anytime anybody's had a retirement home or something in Louisiana, the attorney that we know well always says the same thing. We're going to have to get an attorney in Louisiana.
Yes.
But I've never seen that have to be done with, say somebody has a home in Colorado, a vacation home or something. I've never seen that be a situation where there was a problem with the transferring of that asset.
Okay. And we didn't really have this here, but I'm kind of going through the process, so maybe I can answer some of these. But how long have you seen that it takes on average for somebody to set up a trust? Because we do know a will can be done, very, very quickly. But a trust it takes a while.
3 months to a year.
Depending on how big the estate is, I would imagine.
Well, I've seen the last 2 or 3 years.
Wow.
But it takes a long time. It's a very slow process.
It is, and I'm experiencing that firsthand. We knew that going in, but we're a month into ours, and I know that we've still got, we have a goal in mind because we're traveling overseas this summer, so we'd like to have that all set up and ready to go and before we leave, and they're saying no problem. So I'm anticipating just what you said, about a 3-month process to get
So
it all
that's-
set up.
That's pretty normal. But you're like me. When you do something, okay, we did it. Where's it at? And
Right.
I get it, but it is a slow process. And then there's so many other things to talk with the attorney about, because we're talking about living trust here.
Right.
And there are, as Mark said earlier, there are many, many different types of trust, and maybe someday we'll delve into those. There's, the irrevocable trust, and all those types
Special
of
needs
things.
trust, revocable trust. Yeah, there's all different kinds of trusts. That's
A
for
living
sure.
trust that Mark was talking about, is a revocable trust. So this is a question I used to get all the time. I think people have started figuring it out, but there are people out there going, well, what does that mean? It means, if I have a living trust, what does that mean in terms of, do I have to get a trustee to sign all my checks and all that? Once you get your trust established and get your assets into your trust, you won't know the difference between the way it was when it was a joint tenancy with rights of survivorship. It'll feel exactly the same. And I got my trust done in 1991 after my first parent passed away. I saw how easy that process was for me to take their estate through. And so my wife and I got our trust done clear back then, and that was totally for that reason.
Yeah. All right, gentlemen. I have one more question for you, and Bob, you brought this up earlier. Pour over will, and we already mentioned. You own, a lot of times you will have a will and a trust. As you work with an attorney to develop that trust, they're going to determine what your need and for the will on top of it. Can you talk a little bit about what that pour over will is and why it's important to have in concert with your trust?
I got a full pitcher over here, not a full pitcher, but a pitcher over here, and I've got a glass here. And the glass is the pitcher over here is my trust, and it has my assets in it. The glass is assets I forgot to get into my trust. My car, maybe a checking account. Just had this happen with a checking account. And what the trust says is anything that's not, or what the will says, anything that's not in my trust is going to pour over into my pitcher, my trust. So, for instance, this client had 6 figures sitting in a checking account in his name individually. And because we had the document that said everything I have pours over, the bank said, yeah, then the trustee can start spending the assets out. So very, very important. And I've never seen a trust done without a pour over will.
Yep.
Very good. And if you still have minor children and have a trust, that is part of the trust. Is it addresses that there, or is that part of the will that goes along with it?
No, the trust addresses it.
Okay.
So for instance, we got time for this?
Oh, yeah.
So say a child isn't really good with money, someone can say, well, they can get a third of their money at our death, and they can get a third 5 years later and a third 10 years later. And you can put that in a trust. I've never seen that really done in wills, but I'm sure it could be, but I've never seen it. And you can also do, I don't know what it's technically called, but a trust within a trust. And so, if you even wanted to control it more, as you pointed out earlier, you can do a little bit of management from the grave, so to speak.
Very good. All right, gentlemen. Well, great episode. This is a question I think that, first of all, I think I'm probably represent the average American that kind of always knew I needed it, and as part of the military, I had one, but never felt super comfortable with it. But it was there, got outdated, didn't update it, and then over the last year or two, I've really started this. Yeah, I should probably look into that. So. This is a great episode that we could actually help people understand what these are, why they're so critically important. And I'll reiterate it. Everybody should have, at a minimum, a will. And if you have children, there's really, you have to have a will. That,
Well-
and then
And it's not something that you think about.
Yep.
You know, when you're 25 and life's going 400 miles an hour,
Right,
baby
yeah.
shows up, that's about the last thing you're thinking about.
Yep.
Yeah, and somebody in that age group probably isn't thinking about end of life scenarios.
Right.
And one of the things that Dave Ramsey always said that I always liked, he says, nobody's getting out of this one. Every one of us is going to die at some point.
right?
Nobody's getting out of it. So you might be age 25 and you might not be thinking about when the end is, but it could come at age 26. So always good to be prepared for sure. So great conversation. We hope you enjoyed it. Once again, you can find out more about what Mark and Bob can do for you at schwartzinvestmentpartners.com. And once again, give us a like, subscribe. We try to do this on a weekly basis and try to get an episode out every week. So we'd love to have you join us at the next one. You guys have a great weekend, and everybody, thanks for joining us today.
Thank you.
Thank you.